Next case on the calendar for today is Gustavo, Moran-Zambrano versus the State Department of Highway Safety. Counsel, you may proceed.
Here, please, the court. My name is Tom Copeland. I'd like to reserve, first of all, 5 minutes of my time for rebuttal, if I could. Excuse me. I have the pleasure of representing a young man named Gustavo Moran-Zambrano in this case. And what we're asking the court to do today is to reverse an order of the 8th Circuit Court sitting in its appellate capacity, which upheld an administrative hearing officer's decision sustaining a driver's license suspension that was imposed against our client. There are two primary reasons for our request. Number one, both the hearing officer and the circuit court failed to follow the law in this case regarding the evidence that was presented at the administrative hearing. And secondly, the rules that are used to guide breath test officers in administering breath tests in this state, we say are essentially unadopted rules of the Florida Department of Law Enforcement. And those rules require certain actions that the officer did not take in this case. And the department's position that the Department of Highway Safety and Motor Vehicles' position that those guidelines do not constitute rules, if that's true, means that there are no rules for breath testing in this state. I'll explain that further. And of course,
well, let me ask you, because you probably will need to explain that a little bit further, because if I accept your argument that these are unadopted, then the case law, and I think your supplemental authority, all that was, in essence, that argument, then they're not rules. But you're not really saying we don't have other rules about breath testing, do you?
We have rules that are promulgated. There's nothing in those promulgated rules, specifically Chapter 11D of the Florida Administrative Code, that tells an officer what they're to do when certain things happen during the course of a breath test.
But so you're saying then that you're not saying that we don't have rules. Clearly we have rules. And some of those rules even adopt by reference of the Form 37, for instance. So we have rules, but what you're saying is our rules perhaps are incomplete in some circumstances, so therefore we have no rules? Or why don't we just, the case law says if they comply with their rules, and it would almost seem like regardless of what those rules are, if they comply with their rules, then they're golden. Why isn't that the situation?
Chapter 11D, which refers to Form 37, which is entitled Operational Procedures for a Breath Test Machine, if you look, or in tonsillizer, if you look at that form, what it tells the officer is here's how you do it. Type in the suspect's name, type in your name, type in the suspect's driver's license number, verify that the dry gas cylinder that's attached to the unit is within date, and push the start button. That's really all it says. And then it says, and the machine is then programmed to go through and request 2 breath samples within 15 minutes of each other, and it's programmed that those breath samples should be within .02 of each other, or it requests a 3rd breath sample. That's all Form 37 does. The tonsillizer is also programmed with a whole variety of messages that can come up when there are problems with the breath test.
Well, right. Okay. So I'll accept that there are messages that in essence, the machine's a computer that it can generate because it finds something wrong. But if the department adopts rules, and let's say they adopt much skimpier rules than what they actually adopted, the statute says the department will adopt rules, and the legislature says if the department adopts rules, then, we have this presumption and we can introduce it into evidence. And you're saying that the rules could be better. And since the rules could be better, then in fact there are really no rules and we can have no breath testing.
We have no guidance for issues that regularly come up in breath testing if we don't look at this breath test operator course curriculum that I'm talking about, because there's a statute. And I think the statute actually goes a little beyond what you said. The statute is very specific in this case. One of the most specific enabling statutes that I've seen, and there's some case law dealing with this unadopted rule concept, where a less specific statute was involved in that case. And the court said that there were the procedures that the agency was following constituted a rule, and that because it had never been officially promulgated, it was an unadopted rule. And so that's one response to your question. The other problem I have with the position that the Department of Highway Safety and Motor Vehicles has taken in this case is that the Department of Law Enforcement, who's charged with creating this system and these rules, has previously taken the position in court cases that the breath test operator course curriculum is part of the rules, that that's what they intended. And their specific argument was under 11D.8.008, which is the administrative provision that says if you want to be a breath test operator, here's what you got to do. There's age requirements and things of that nature. But they also have to take a course approved by the Standards and Training Commission of the FDLE, an approved course, which the statute says FDLE had to establish an approved course. They had to have one approved curriculum for that course. The officer has to pass that, take that class, and then take a test based on those course materials and pass the test with at least an 80% passing rate in order to get a breath test operator permit to administer breath tests in the state. So the statute's very specific about what FDLE was supposed to do, and FDLE has taken a position that the breath test operator course curriculum is in fact part of the rules, and when they created the system, they intended that to be the case.
Well, I mean, you know, if I understand the way the intoxilizer works, in essence, we're trying to test your deep lung air, that where the exchange from the blood to the lungs takes place, and then we calculate a percentage to come up with the percentage of blood, alcohol in the blood. Right. And to get the deep lung air, then we need a certain quantity, and the machine checks that by the more you blow, it keeps going up, and then when it levels off, then the machine takes a snapshot and says, there it is. So a slope problem is it starts to go up and then it drops down, and it doesn't do the projected path. And what the operator testified to in this case was that your client was huffing or, you know, stopped breathing. So realistically, what I could do if our court ruled like this is I could go in, agree to take a breath test, and then just huff. They have to wait another 20 minutes, huff. They have to wait another 20 minutes, huff. And I could, in essence, frustrate the entire purpose of the statute and deny the state any evidence, couldn't I? You
could not. Here's the reason why. You have a misunderstanding, with all due respect, about what the breathalyzer measures. It actually measures three things. It measures time, volume, and slope. Time is a minimum of 1 second of continuous air. Volume is 1.1 liters of air, which if somebody blows with enough pressure to open the valve in the machine for 1 second, you'll get 1.1 liter of air. And third is slope, and FDLE has repeatedly testified that it takes time, volume, and slope to render a reliable test result. And there's case law where the current head of FDLE, in fact, Laura Barfield, came in the case of State versus Barton, which was actually a consolidated county court case in Volusia County, and specifically testified to what I just said: time, volume, and slope.
Okay, so if I accept that, why couldn't I still just, you know, not go a full second, not do 1.1 liters, and you have to start your 20-minute waiting period over again because the slope is going to come up as a problem?
Here's why. I'm sorry, I didn't mean to interrupt you. Here's why. The machine measures volume, and if you don't blow a sufficient volume, you get a volume not met message. And in this case, we got slope not met. We didn't get a volume not met message. So the officer's testimony that my client somehow affected the result by not blowing properly is disproved by the fact that there's a volume measurement device sensor on the breathalyzer, and had he gotten a volume not met, then your argument would be correct. He caused it by not blowing a sufficient volume. But in this case, all we got was slope not met. So obviously...
Does there have to be any evidence of regurgitation?
The fact that you got slope not met is pretty good evidence of regurgitation.
Well, I mean, it doesn't mean that there was regurgitation. I mean, it wouldn't regurgitation in many... I mean, if you look it up in the dictionary, it means to empty the contents of the stomach through the mouth. And you know, it seems like it's not burping. It seems like it would be fairly obvious if he regurgitated.
It's not simple burping, but of course there are people with acid reflux disease who have a defect in the valve at the end of their esophagus who can belch and cause contents to come up into the esophagus. And I think we've all seen people who may have heaved but not actually expelled any material and swallowed it back down.
Did your client testify that that's what he did?
I'm saying that that's what slope not met is designed to test for.
But they also said it tested for other things, too. I mean, that wasn't the only way that you could get slope not met, was it?
Who said it tested for other things?
I thought that was the testimony at the hearing.
No, there was no testimony to that effect at the original hearing. All the officer said was that he believed that the client didn't blow properly by stopping and starting.
So it's your argument that the only way slope not met could be made is through regurgitation?
I don't know if I would say it's the only way that it can be done. I would say that that's what the slope detector is designed to make sure doesn't happen. And that's the reason why the breath test operator course curriculum, it says specifically, here's what you must do. And it uses the word must.
So your argument is really that these rules are inadequate and they need to be struck, and if these rules are struck, there are no rules for anybody, and every breath test in the state of Florida is invalid that was conducted under these rules. And that's the impact of your argument.
And the alternative is to say that the breath test operator course curriculum is, in fact, incorporated within the rules based on the argument that...
But we can't do that, can we?
Pardon me?
We can't do that, can we?
Well, based on the testimony of Mr. Skipper, who was an FDLA employee that said he was instrumental in the development of the rules, and then when they wrote the rules and they wrote the curriculum, that they intended for the curriculum to be part of the rules.
But if we have requirements that the rules have to be specific, that we have to notify people, and the legislature has been very hostile to this concept of agencies just having these implied rules or these unwritten rules without the public having a chance to comment, I mean, really, isn't that taking us beyond our authority? I mean, wouldn't we really only be able to say these rules are not adequate to satisfy due process, and therefore no breath test is valid? I mean, we really can't be adding to the statute and say, well, we don't really care what the legislature said about 120 and how to go through rulemaking. We'll just incorporate a new rule and say when this slope not met comes up, we'll, and I'm sorry, I'm into your rebuttal time.
And I'll try to, maybe I hopefully won't need quite 5 minutes, but I do want to respond to what you said. I think there's two things the court could do. Number one, the court could say FDLE's previously taken a position that there are rules based on 11D-8.008, which says you have to take this course, which includes this curriculum, to be a breath test operator. So we can say it is part of the rules. In this specific case, they didn't follow the rules because the officer didn't restart the 20-minute observation period after he got the slope not met reading. That's one option. The other option is to say, in fact, these breath test operator the breath test operator course, which is this document right here, which is in the record, is in fact an unadopted rule. If you look at 120.5216, which defines a rule, you look at 152.20, which defines an unadopted rule, the rule is a statement of general applicability that implements, interprets, or prescribes law or policy, or describes the procedure or practice of an agency, and includes any form which imposes any requirement. Unadopted rule means an agency statement, which is the rule that meets the definition of the term rule but has not been adopted. This document here is what every breath test operator has to take. In this form, there's a section here that talks about all these messages that an intoxilizer can return when a breath test is administered. Among those, on page 46 of the appendix, 23 of the actual booklet, is slope not met. It says out here under actions, the operator must perform another 20-minute observation. If you look at all of these potential messages, each and every one of them tells the operator what to do. If this is not part of the rules and the operator doesn't have to follow this, then that means when they give a breath test, and any of these messages that come up, 2.5 pages of them, if any of these messages come up, they can do nothing or they can do anything they want to. And there's no way to challenge what the reliability of the breath test. And it's real important to note that 316-1932 says such rules that when they authorize the department to create rules must specify precisely the tests that are approved by FDLE for reliability. So the main goal, and Laura Barfield testified to that in the case that I cited to you a while ago, that their goal is to achieve reliability of results. And so I would ask you to consider asking the Department's Motor Vehicles Council if we don't follow this, when any of these messages come up, any of these 20-some-odd messages come up, what is a breath test operator to do? And see if he can tell you what the breath test operator should do. Thank you.
Good morning, Your Honors. Judson Chapman, Senior Assistant General Counsel for the Department of Highway Safety and Motor Vehicles, here on behalf of the Department, and may it please the Court. I think the one key issue here that has to be kept in mind, as with any kind of certiorari review, second-tier certiorari, is whether the confines of that review are actually being met under the standard of review. And we submit on behalf of the Department, as was set forth in the response, that miscarriage of justice standard has not been met in this case, as it narrows up the review chain.
But isn't a failure to follow the correct law, wouldn't that be sufficient for a second-level cert review?
I think that is included in
So would it be if, in fact, your department or the deputy or I guess the Florida police officer, if he was in fact required to perform or wait another 20 minutes, and this really was some kind of unadopted rule incorporated by reference, I mean, if we can get all that, I mean, but at that point, if the circuit court says, you know what, it was good enough, is that a departure sufficient for a second-level cert, or the fact that he looked at it and rejected it or evaluated it however, I'm just wondering if you're really saying that he did not, the second prong.
Well, I think the answer to that is the statute requires that the test be administered in substantial compliance with FDLE rules and methods, and I think here they were met.
Now, wonder if you had, instead of however many rules you have, wonder if you had, fewer. Mm-hmm. Wonder if you had, you didn't have the rule, for instance, of Form 37, but they used it. I mean, would that render all breath tests inapplicable or invalid?
No, I think it still represents the statement from the alcohol testing procedural piece of FDLE on what they generally require and have said reach rule status insofar as operation of this machine. And Form 37 does provide a procedural checklist.
So is it your argument, I understand that you're making an argument that he doesn't even qualify for second-level cert, but if he did, is it your argument that the fact that they comply with whatever rules are in place, and they're not arguing, if we reject the implicit rules, that his compliance with the rules that were in place are sufficient to affirm the suspension of his driver's license?
Yes, I think that's what Judge Lott clearly found, that there was no elevation of this manual, this operator procedure, beyond anything more than a training course. And
that would be true even if it could be established beyond any doubt or whatever standard we want to use, that there is a better procedure that could be used.
I think so.
So you're not obligated to come up with the best procedure, you're just obligated to come up with some procedure.
Well, that's basically correct from the standpoint of FDLE's duty the statute does say they want a uniform procedure, and they are the folks vested with approving the machine itself and then the credentials of the operator, and then procedurally how it's to be operated. And if that is complied with, that is what the case law says. That's what the Byrne case, which I submitted yesterday.
Do you think the department has the authority to have implicit, unadopted rules?
Well, I'm sure every agency has several unadopted rules, policy-wise. Of course, that is to me a question for another day, another forum, a 120 forum on a 12056 challenge. That is really not within the parameters of what we have here, which is an admin hearing officer reviewing the contents of basically the arrest documents.
I guess what I'm asking is if we think that it might have been better, obviously we don't know the results, but it might have been better if the officer sat there for another 20 minutes or someone sat there, it doesn't have to be the operator, but someone sat there with the defendant for another 20 minutes, and we decide that would have been better. Can we kind of incorporate that into the rules by judicial ruling, or do we have to say you don't have sufficient rules and therefore none of these tests are valid?
I don't think this Court respectfully is entitled to incorporate it and declare it to be a rule in this context of what we have in this kind of a review. I don't think that the alternative means that you've got to throw everything out. I mean, if that was your belief that somehow this needed to be done, because as you've already observed, Your Honor, there was a participation by the petitioner here in starting and stopping, according to Officer Pruitt, who was the breath tech.
And whose testimony could be accepted. I mean,
yes, that this was, and then that becomes a credibility call, if nothing else, for the hearing officer to say, yes, under those circumstances, based on the individual not, in effect, following procedures, which he subsequently followed fine, but does that necessitate another 20-minute observation? When the officer said, I gave the original 20, I checked for the regurgitation and anything in the mouth, and we proceeded. So it makes no really practical sense to go into do another 20-minute observation, and it's simply not required by the rule. In fact, 8007, I think it's paragraph 3, specifically has language in there that the provision relative to the observation shall not be construed to otherwise require an additional 20-minute observation before administering a subsequent sample. That is a rule that basically tells me there's no need for another 20-minute observation period. And the rule, because that is a rule, that would countermand whatever we may glean from this operator manual. The rule prevails here, and that does not require a second observation period, particularly under these facts when you've got a valid original observation, seeing no defect in what
I wonder if an individual is arrested in Gainesville on one night and this operator is there and the slope not met signal comes up and he chooses not to wait 20 minutes, but the next guy the next night has a different operator and he does wait 20 minutes, an additional 20 minutes. And is this a problem that we might have a response? I mean, I think that's part of the argument is that once this signal comes up, not everybody's going to respond in exactly the same way. And is that a problem?
I don't see it as a problem. I think it's a problem that was not really addressed at the hearing, where the driver presented no testimony either from himself or from any other witness that would make the basis in the record to have that as some kind of really inherent problem with the second blow.
Is slope not met only generated when there's regurgitation?
Well, I'm not the expert here, and there wasn't any testimony on that. All I know is what's in the I honestly don't know, Your Honor.
But what we're concerned about is regurgitation, correct?
No, not necessarily. I think it's. I think if you read those guidelines, it does talk about, as I think the court was originally describing, that you're getting enough volume going in, and suspicion is going. The readings are going up from the full lung sample. I don't think it's necessarily related to regurgitation. I think that has an element. The regurgitation, it has an element of getting back mouth alcohol that gives them potentially a false reading.
And wouldn't that create a bump? I mean, that wouldn't, a mouth alcohol, because it wouldn't be sustained and it wouldn't have the plateau, I mean, wouldn't that create problems of itself?
I suppose it could. It could. I'm not the end-all on the intoxilizer, that's for sure. I'm just looking at it from the standpoint of we're dealing with basically a statutory privilege to drive and the admin's suspension review process. And in that context, per Judge Lott's order, the argument here does not amount to either a miscarriage of justice or a rebuttal of the presumption created by the substantial compliance when the agency has the proper documentation of the test results, that it was administered according to the applicable rules, and here is the reading, as well as the test certificate. And in this case, the local test certificate from the agency was, I think, just 2 or 3 days preceding this actual administration. So the machine was operating, so far as we know, at least from a presumptive proof situation, properly. And as a result, there hasn't been any really challenge to that other than this attempt to elevate the policy manual into a rule, and this implied incorporation by reference, I don't think amounts to a real error at law sufficient to get in the area of a miscarriage of justice. So as a result, the court below, in her analysis, was correct and legally correct. There is no requirement of Florida law through statute or rule to require a second 20-minute observation period when the slope is not met. As a result, the agency's speculative opinion that the Judge Lott's order needs to be recognized, affirmed, and that the petition should be denied.
Should the petition be denied, or should the case be dismissed? I mean, what's your first position?
Oh, it was interesting because she dismissed it. There has been, and then went back, I think, at the suggestion of probably the petitioner to make it a denial. Denial, I think, is what we normally see, as opposed to the dismissal.
Well, if they didn't meet the standard, if this is just a second appeal, they didn't meet the second level cert, and the appropriate remedy from us would be to dismiss because it doesn't qualify as second level cert. But if it does qualify as second level cert, but they just failed in their argument, then it would be denied.
I can accept that. You're asking me which one I prefer?
I was wondering which one was your position. In other words, did they, is your number one argument they don't belong here, or is your number one argument is?
My number one argument is they don't belong here, respectfully. So I guess in that case that would be motivation to enter a dismissal. That's the prime argument I would have. They haven't met the standard. If we're going to get beyond that, and as you say, in the merits, I don't think there's merits to that either. Therefore, the denial. But in either way, we would request that this court need not intervene in this particular instance. Thank you so much.
Thank you.
Thank you, Your Honor. I just have a minute, so I have to hit this really fast, I guess. Number one, with the question of whether we should be here or not, I started off by saying that at the original hearing, the hearing officer, Neil Judge Lott, followed the proper analysis, if you will. Initially, when the department submits their documents, a presumption arises that the breath test is okay. Under the case law, if we present credible evidence that the breath test was not done in substantial compliance, it shifts the burden back to the department. We showed from the documents they submitted the breath test affidavit showing the slope not met. We submitted a letter from former FDLE Director Guy Tunnell showing that time, volume, and slope are critical to reliability, and we admitted the breath test operator manual to say, here's what the officer should have done, and he didn't do it. The hearing officer overruled our objection. We raised that with Judge Lott. She never addressed that. She recognized in her order that her standard was whether procedural due process is accorded, whether essential requirements of law have been observed, and whether administrative findings are supported by competent substantial evidence. Our argument to her was they never came back after we raised a credible issue of the substantial compliance with the rules. They never presented anything. So they didn't meet their burden, which had shifted back to them at that point, and that's a primary reason why she should have ruled for us. With regard, I guess I'm about out of time. Can I have a 30-second or 1-minute extension?
30 seconds.
Thank you. One thing that Mr. Chapman said that I have to point out for the record is the officer never said he checked for regurgitation. That's what Mr. Chapman testified to. Read the transcript, and you'll see all the officer said was that he didn't blow properly because he started and stopped. Secondly, 878.0073, which he quoted, is cited in my brief, and I said if you look at my analysis of that provision, it's consistent with my position and inconsistent with their position. It's consistent because the statute, first of all, it's addressing mouth alcohol, which is what? Slope not met. And it says the officer has to ensure that nothing's taken by mouth and that there's no regurgitation before doing the test, not the first test, the test.
Okay, Counsel, you've had your extra minute.
Thank you, Your Honor.
All right.